this case that the Supreme Court is hearing today that gets to the heart of these nationwide injunctions that have been issued by district courts across the country to block policies of the president. Now, these have happened under both Democrat and Republican presidents, but they always seem to tick up during the Trump years. As a matter of fact, the statistic is around 67% of all nationwide injunctions that have been issued have been against President Trump, either during this 100-plus days or the 4 years prior during his first term.
We represent West Virginia in this case. The underlying action is the birthright citizenship issue, but what is before the court is these universal injunctions. And look, conservatives have been guilty of going after these too. I mean, famously the state of Texas. But here's the reality, and I think the universal injunctions are dangerous for the exact reasons that Justice Alito was pointing out. Now, it's very close, Will. I could tell you just by the oral arguments. It is a very closely divided court. It's not clear where Justice Gordon, the argument's still going on right now. Jordan's inside the court with the Attorney General of West Virginia, J.B. McCuskey. So they're inside the courtroom right now, but I've been able to listen to it. The reality is this is, I think, looking at right now a 4-4 case, and Gorsuch could be the determining factor here.
We are there with the Attorney General of West Virginia because we are representing West Virginia in our amicus brief that we filed in this case. And so it's very important. This is the work of the ACLJ, pushing back against these nationwide injunctions. Because one district court, one judge, should not have the power to consistently block policy of the President of the United States before there's ever briefing on the merits, before you get to any sort of details in the case. They just put an end to it.
Some district courts have issued nationwide injunctions, and this happened in the Trump administration, and it has also happened in the Biden administration. So this has no political tilt to it. But some district courts have, very quickly issued nationwide injunctions to stop a policy in its tracks. That something that the president and or Congress has determined to be the national policy, and it just one district court stops it. And then you combine that with the ability of people to forum shop, to go to a particular district court where they think that will be the result. And you look at something like that and you think, well, that can't be right, that one district court, whether it's in the Trump years, people used to go to the Northern District of California. And in the Biden years, they go to Texas. And it just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through a normal process.
That is precisely the issue before the court today. That a district court judge can stop a policy of the president in its tracks and leave it stopped for years as it goes through the normal process. That's what we're fighting against today. That's why Jordan is there today at the Supreme Court with the Attorney General of West Virginia representing that state and their interests before the Supreme Court in our brief, pointing out that this can't be right. As Justice Kagan said,
she's correct for a number of reasons, not the least of which is the fact that the court record below has not yet been developed. So in other words, you have a single district court judge issuing an injunction based on an incomplete judicial record and saying, hey, I will determine whether or not the executive branch can actually run the government.
This really should not be a liberal conservative issue. This really should be an issue of how do we want an unelected district court judge in Spokane impacting citizens of the state of Georgia or North Carolina or Texas or New York. I mean, it's ridiculous.
What you are seeing is, for the first time, to my knowledge, the Supreme Court tackle this issue of nationwide injunctions and what is the limit of the authority of a district court judge. And there are hundreds of them across the country that have the power. This appointed judge, unelected. This isn't the same as a state court judge, which may be elected by the people to represent them. Now, obviously, a state court judge can't issue a nationwide injunction. These are appointed judges by presidents, confirmed by the Senate, that at some point along the way have acquired the power to completely block the policy, the foreign policy, the executive actions of an entire branch of government. And this is what's before them. It is almost an existential constitutional issue that we're seeing before the court today as it pertains to how much power these judges have.
The idea here that you've got what could be either a very straightforward case or a very complicated case. And I think that the easiest way to look at this is, should district court judges be able to stop the actions of the President of the United States because they don't like the policy interpretation, or do they have to go through a court process? It doesn't mean that our president gets to do whatever they want, whoever we elect. And that's obviously, you can't just look at who the president is now and say, well, I like them, so I want them to have this power, but I don't want the next president to have this power. At the same time, 2 hours before the U.S. Supreme Court, without the lower courts taking this kind of time, the lower courts who considered this, who issued these nationwide or universal injunctions, didn't take the time that the Supreme Court did today to even consider these issues. These were quick orders, politically charged orders to prevent the President of the United States from carrying out their function to execute the laws of the United States. What are the ramifications of going forward and just saying this is the new accepted practice of the United States, that district court judges get to decide when to shut down the executive branch from even beginning?
Do you think really that the opinion hinges on whether or not some of these justices, like Justice Kagan, can separate themselves from the underlying EO that this injunction is related to and look at the issue that is actually before them, which is district court judges issuing these nationwide EOs, stopping a president's policies in its tracks?
This, again, is bigger than birthright citizenship. It's procedurally much bigger. It's, if you live in one state, can the action, or one district, can the action of another district court judge stop the entire administration and functioning of law in its tracks? And so, again, we live in a government with co-equal branches, but the judiciary is divided. And so we have, again, we started in the district court, we go to the Court of Appeals, and then we go to the U.S. Supreme Court. And you have basically the argument before the court today is you don't fix things quick enough. And this case got there within a matter of a month. But again, we'll get the opinion of the court, and we'll continue the fight. I think this is just the beginning of the fight for the Trump administration to be able to carry out its policies. And again, the will of the people who elect our executive branch leaders, like the President of the United States, to carry out the functions of our government.